Thank you for tuning in to the Brach Eichler Talks podcast, where we explore and discuss today's trending legal topics. In this episode, we discuss a recent labor and employment law alert from Brach Eichler, titled, "The FTC is Challenging Non-Competes. It may be time to review your practices." Employers may be under the impression that non-compete agreements are not illegal, or that the enforceability of such agreements may be limited only under state or local law, or that the federal government is not actively seeking to prohibit their use. All of those impressions, while perhaps justified, are wrong. Within the past few weeks, the Federal Trade Commission, FTC, published a proposed order against a nationwide pest control company, Rollins, Inc., to cease requiring all of its employees, other than its directors, officers, and senior managers, to enter into non-compete agreements, and also issued letters to 13 other large pest control companies, warning them not to require all their employees to enter into non-compete agreements. The misimpression arises from the FTC's failed efforts in 2023 to adopt a uniform regulation generally limiting the enforceability of non-compete agreements, except in certain limited circumstances. While the FTC has abandoned that one-size-fits-all approach, it is actively investigating individual employers and assessing whether the use of non-competes is unjustified, overbroad, or otherwise unfair or anti-competitive. As the chairman of the FTC explained in a statement that accompanied the proposed order against Rollins, Inc., an indiscriminate general policy approach of requiring every single worker to sign a non-compete agreement irrespective of the worker's position or responsibilities, cries out for scrutiny under the antitrust laws. Employers should take the opportunity to reassess their non-compete practices. Protecting legitimate business interests, particularly in the context of a corporate transaction or with respect to employees who have access to non-public competitive information, will almost always be justified. On the other hand, rotely requiring all employees to sign non-competes without any independent justification to protect confidential information will invite scrutiny. For more information about the FTC's actions against non-competes and for legal guidance about structuring a defensible non-compete program, please contact J. Sabin, Esquire, Member, Labor and Employment Practice at 917-596-8987 or jsabin@bracheichler.com. Don't forget to subscribe to our podcast on Spotify, Apple Podcasts, and YouTube. Follow us on LinkedIn and Facebook for updates on new episodes. For more information and resources, visit bracheichler.com. This is intended to provide general information, not legal advice. Please contact the authors if you need specific legal advice. Brach Eichler LLC is a full-service law firm based in Roseland, New Jersey with over 80 attorneys. The firm is focused on the following practice areas: healthcare law, real estate, litigation, trusts and estates, business transactions and financial services, personal injury, criminal defense and government investigations, labor and employment, environmental and land use, family law services, patent, intellectual property, and information technology, real estate tax appeals, tax and cannabis law.